Good afternoon. Thanks for joining us, and we're back. So the next time we'll have this session, that'll be 24th, possibly. Okay, so court is being adjourned, and it's to do with KPMG that had some days, about a week plus, then to get this thing sorted out. We have been watching Dr. Farijan, Philip Addison, and Counsel for EC as well, because she identified together with the other counsel, Stanley Lita and Chacho Chikata, in court, well, facing the bench there and making or arguing out their cases for that matter. Election petition hearing at the Supreme Court, and we're back here. I say good afternoon once again on behalf of the crew here. We will try as best as possible in the next few minutes, perhaps the next hour, to walk you through what has gone through in court and get some understanding of it before we take a break and adjourn the session possibly to the 24th of June. Let me welcome quickly here those who have put in our studio here. George Tetewayo, who will speak for the NDC, is a legal practitioner. Then also Gary Nimako Mafo, who will speak for the NPP, also a legal practitioner. Unfortunately, today Dr. Ampa is unable to join us. I'm sure later also we will have him here. My name is Henry Herbert Mam. I'll be host for now. Thanks for your time, gentlemen.
Thank you very much.
So, court adjourned to 24th, and KPMG has work to do. But let's attempt to go through some of the things that have happened in court today. It started well, and then on the note of the ballot papers printed, the number printed, the number used, I think the pink sheets as well, used, and then those left. A lot of back and forth on it, and Doctor has been asked to produce them.
Yes, Henry, good afternoon to your cherished viewers. I think it's another bright day. Good cross-examination from Mr. Philip Addison. A lot of revelations have come up today. I'll categorize them in three main points. First of all, the issue about the printing of the ballots, then the pink sheets which were duplicated and printed, the role of presiding officers, and voting without verification. If clearly you listen to what happened in court today, you realize that Dr. Farijan made it especially clear that they printed, first of all, 27,000, and then subsequently they printed additional 27,000, making 54,000. And then, we look at the polling stations in the whole country, 26,002 polling stations. So when you do the subtractions, clearly, it means there will be an excess of, some of the pink sheets, which obviously will have to be in their custody. And then when he's being asked about it, whether he can produce it, he says that unless it is not stolen, then they will be there, But the fact of the matter is that these so-called duplicate pink sheets, were deployed. The additional ones were deployed. Now, if, for instance, Henry, you have already ordered for 27,000, and in your own estimation, 27,000 was enough to conduct the elections, i.e., at the time that they were going to election, it was settled that the participants were 8 candidates, and you now have to get additional one. Why do you have to deploy the additional one? Now it's being asked a question about it. They say, well, if they are not stolen, then obviously it will be in the custody of the EC.
You have had access to tamper bags. How do you get them?
And I have told you constantly on this platform that you see, I have told you that on this platform. You see, it matters not how you get your evidence. What is important is that evidence, more or less, is it admissible?
Don't you?
Is it relevant to proving your case?
Now it's an excuse for him to say he has unable to bring all of them because people have been stealing. Sometimes it turns out that those tamper bags actually bags from his stores. That means somebody from your end. That's it.
No.
You can make a case.
No. I don't think anybody stole anybody and brought it to us. I don't think so. You see, at the end, the EC, as I said, is a custodian of all these original pink sheet, collation sheet, ballot boxes, ballot papers. I mean, the EC keeps all these things. You understand? So, he said that, well, they will be there if they have not been stolen. Well, I hope maybe he can produce it to the court to show that indeed these excess duplicate pink sheets indeed are still in the custody of the EC, because he himself has also stated in his evidence that they deployed the additional ones that were supplied to them. No, that's my. Why do you have to deploy the additional ones if, in fact, the ones that you had already were enough to do the elections?
But he said that, and
they were picked at random. So they were picked at random.
The leftovers.
So we will see. We will see whether he will be able to bring it in the event that. By now you say if the going time you can bring it. So let's see whether you can bring it.
Okay. Let me add this other one too about the role of the presiding officer.
Yes.
That also came up. You see a lot of questionings from us Addison, and it's just to substantiate your belief, your claim, all this while that the presiding officer is a sole man in charge. The agent actually is just to observe, cannot do anything without the support and sanction of the presiding officer.
That is very correct. You see, Dr. Farijan today at that portion was very honest and truthful. I suspect that maybe somebody is telling him what we have been saying here. You see, he was very frank and honest with the court. He said, yes, the presiding officer, he can even sack the polling agent or the party agent. When in this, own interpretation, when you come there, you come and misconduct yourself. And the person who determines who has misconducted himself is the presiding officer. He can sack you. The same person, the one who validates the results. The same as the one who can pour the papers on the ground and even count. So there's a lot of, a huge task on the presiding officer at the polling station. You understand? So basically, he has to validate the results. It's not validated by the party agent. So clearly, you can see that the party agent is there, like Baumia would say, an exalted observer. Because you see, the role basically that he is there is just to, you sit back and then you check and see whether things are done rightly or wrongly, and then you can even report to the same presiding officer. He can choose to ignore you. So the presiding officer has got an onerous role when it comes to the conduct of elections in the polling station.
Okay, so but the observer also is given the opportunity to put down his comments.
You cannot
say, okay, after this is my name, this is my signature. What I've observed is fraud.
Oh, you can. No, you can observe, but you see, in an instance where the observer, for instance, maybe you can get up and go to the loo. You get up and go. They don't know
everything you see.
In an election, there have been a polling agent before. It's not. You cannot sit there all throughout the whole day. I mean, we are human beings. In the course of time, you can even get up and go to private, back and forth and come back. What if the time that you are there, something untoward happens? By the end of the day, what you must understand is that the person to protect the ballot, the integrity of the elections, is the presiding officer. You see, he must ensure that the individual person who is there, your ballot is protected. Because at the end of the day, if he is there with all the huge tasks on his head, and then at the end of the day he's not able to protect the ballot, it means that the person or the party without a party agent there, will be muffled out. You understand? So we cannot discount the role of the presiding officer at all. His role is onerous. That's the reason why you cannot just say that anybody can be a presiding officer. That's why I took him to the education of the presiding officers. I said they are reasonably educated. And then in his term, you must have done your SSS, reasonably educated. Now, in the face of these so-called reasonably educated characters, Dr. Farijan himself has admitted that there are errors on the face of the record, patent errors. You see, and he has admitted that these are errors. What we call irregularities, he called them errors. Now, if indeed these people were reasonably educated, and you rely on them to conduct the election, and that is also saying that they have been relied upon in all the years that we conducted elections. But I was aware that teachers were being used most of the time, and even last year, Doctor was even appealing that the teachers should be allowed to be used, and then the teachers association, they said that they had issues. They won't agree because they don't want their members to participate. But he is saying today that some teachers were even part of the elections. But you see, in the face of all these things, we have seen challenges with the elections.
So you are raising issues also about the quality of personnel.
Exactly.
Having gotten people of not too good quality, for which reason?
You see, sometimes I have to be a bit sublime and a bit charitable and have some sympathy for the man. You see, when he becomes honest, I have sympathy for him. But when he becomes evasive, then I realize that you are trying to endorse the wrongdoing of your own agents and officers.
Okay.
That to me is the problem.
Okay.
You get my point.
Okay.
If he comes in and the way he was going today, that these are the way that he must do, the work they should do, and at the end of the day, if for some reason they didn't do those work where they come and admit them, I mean, it makes life easier for everybody.
Regarding the role of a presiding officer and what an agent can or cannot do over there, I mean, there was one academic exercise that took place there. I think I'll reserve that until after the comments. That's when Addison sought to use or to get Dr. Farajan to read a law in support of his argument, a law which had been repealed and all that, and which took some time for a lot of exercise to be done and ruling on. Let me hold that for the time being. Let me put these two things together about the ballot papers. That's Farajan is been asked to bring, and which he thinks he will need some days to be able to do that if they are not stolen. And then also the emphasis that Addison has tried so hard to put on the role of a presiding officer, discounting to some extent how much power the agent has, in your view. And for a very long time, the respondents have been putting a lot of weight on the presence of the agent.
Thank you very much, Henry. I think that it has played out very well in court. Good afternoon to your cherished viewers. It's played out very well in courts today. And if you want to discredit the enormous tax of a party agent, you'll be missing the point for electoral processes. Because, Henry, like Dr. Farajan kept to say, about 130,000 presiding officers, most of them, temporary workers, temporary staff, and even with that number, you get to see that the workload is very difficult to mount 26,002 police stations across the country. So if you have party reps, party agents, and from day one you want to tag them as mere observers.
Let me, I beg you, this one, forgive me. It's your time to flow. Let's just go back to the Supreme Court quickly and get some opinions quickly and come back. Forgive me, this is not true, and I hope that I'm not tagged.
No, that's fine.
For that one. Let's take some shots. Let's take some arguments. We understand Laura Kufu is speaking at the Supreme Court area. Let's see if we can get that one and then get back here quickly.
Today we have some of the people we are speaking to.
Forgive us, we're having some problems. Yes, that's what technology does sometimes. Let's come back to the studio. Forgive me, and now you can flow.
Thank you very much. So I think if you are a candidate, in fact, if you are a political party in such an election, in fact, an election to more or less inaugurate who must lead the country, and you want to see your party agent as mere observers, it's very difficult for the Electoral Commission to take that position, because then the whole workload becomes that of the EC, which paramountly is not the case. Because, Henry, you are an interested party, in fact not an ordinary party for that matter. You are seeking to rule the country, so you need somebody able enough to represent you. So sometimes, in my view, I think that the people who represent the parties, the agent, they rather should. Basically, there are certain limits for the party agent, like Dr. Farajan just said. They cannot tamper with, for example, voter register. They cannot tamper with the ID card. They don't inspect ID cards of possible voters. More or less, they don't confront anybody at the polling station. These are enormous duties that the presiding officer does, but then the party agent cannot do. However, now that you sit at one point and watch the processes, I think you have the upper hand. You are more or less the captain. You are watching whatever is going out there. So if you come out and then you want to delimit the power of your party agent, it's clearly out of place. And you saw that the law that was brought in, CI 75, there's a particular provision on party agent, what they are supposed to do. Even let's talk about Article 49. Council read it the last time here, that when it comes to signing of the pink sheet, a presiding officer, and as I also read, to add to what he read, that a party representative agent must sign. Even the constitution will make provision for you to sign. It tells you that a presiding officer as well as a party agent, for the expediency of an election, for the transparency of an election, should be seen as two in one. However, there are certain limits that the party agent cannot go.
Have their rules.
But Harry, that does not make them exotic. It does not make them mere observers, because you have the interest of your party at hand. And let's look at the printing of the ballot papers. Dr. Fraja made it clear that from day one in all the printing houses, reps were there. So at every point in time where it is very critical, reps were there, and reps of the candidates for that matter. And so they are not just ordinary people at the polling station. And if we want to relegate them to that background, then we are making a mistake. Then we really do not understand the enormous presence that they have, the weight that they put onto the credibility of the vote so cast at that particular polling station. So it will be very erroneous to try to paint the picture that a party agent who certain laws have considered, like I quoted Article 49, have considered them, that if a party rep is there, the fact that a party, Lawyer Addison is trying to push the witness to admit that if a party or a candidate does not send a rep, is that fatal? Yes, the witness admitted that will not be fatal, but we have laws. So long as elections are concerned, we have laws in this country that has also given recognition, has taken cognizance of the party representative or party agent for that matter. So in one vein, you might think that the word may is used, that it's not so paramount that you must send a representative because the electoral officers are in charge, security officers are in charge. But yet there are other laws, provisions of statutes and substantive laws that indicate that you need somebody to look at your interests. So if they are there, possibly their impact is great. So for Lawyer Addison to try to lead the witness in his cross-examination to center everything on the presiding officer, because I think that, and you said rightly, that is what he seeks to be doing. He seeks to be doing the cross-examination in such a way that all the blame will be shoved or pushed onto the presiding officer. For that matter, every integrity at that particular police station must be hinged on the quality of a presiding officer, and that is erroneous, because you are taking out the party agent. And I'm saying that party agent, per some statutes and some laws, the Constitution, Article 49, reminds everybody of a party representative or candidate that you must sign alongside a presiding officer. So you don't do cross-examination seeking to relegate to the background the importance of a party agent or a party representative, and then portray that all the work must be done by the presiding officer, and so therefore you shift the blame onto the presiding officer for all errors or all possibly human deficiencies that come up. You shove it on it, and then you equate that deficiency onto the electoral commission, because these presiding officers were temporary officers of the electoral commission. So
I think by extension, in cases where they did not sign, that also for him would mean that something has gone wrong there.
No, I think in the previous encounters, I think the witness has really admitted that we have on record that about 3.5%, that is about 905 pink sheets. As it stands now, it's about 905 pink sheets. The petitions are 1,000 and over there about, but the EC's position is that about 905 pink sheets out of the 26,000 polling stations are not signed, and that represents about 3.5%. So according to the EC and the position of the EC, it is true that some 905 pink sheets were not signed by their officers, but the EC have accepted responsibility and has gone ahead to add that, my lords, in this event, the problem here will be that if unsigned pink sheets inure to the benefit of one candidate, of which per the record of the EC, it's not happened. They didn't sign, all right, but it did not inure to the benefit of one candidate. It all went against all the 8 presidential candidates. If a pink sheet was not signed out of the 905 pink sheets, it was against all the 8 candidates on the ballot.
Okay, what you address this one about the ballot papers, the pink sheets, the extra pink sheets which he's been asked to bring, and in case that he's unable to bring them because he's put a caveat in there, that is if they're not stolen, assuming he's unable to bring them, what would be your reasons for them?
I think the witness, Dr. Farijan, has made it clear. And when he's speaking, I tend to try my best, not my strain, but I want to follow, because like Lawyer Addison said, most of the things he's saying will be the gravamen of the judgment to come. He stated clearly that the pink sheets are not kept in Accra; they are kept at the various, let's say the constituency center, or more or less the polling center, because definitely they leave the polling station. But they leave the polling station because the polling stations are just ordinary area, designated area. They could be under a certain tree, and so they are not places you can keep them. But when it comes to the constituency center or the coalition center, which are the offices, they are kept there. So first and foremost, on record in open court that these pink sheets are not in Accra. So now that you've tasked him to produce them, they have to correspond to all the 26,000. No, now that it's not the pink, it's not the polling station, but more or less, if it's 26,000 polling station, the coalition
are the district offices.
Yeah, they will not be up to 26,000. They will not be up to 26. They will be far lesser than that.
Hundreds,
yeah, far lesser than that. So this pink sheet will be in those custody. So now the EC has to go back and look at those in Accra, and the ones that are in Accra, we try to ship them in for EC to have the entire number of pink sheets for it to be used for such a purpose. Secondly, he also made it clear that this issue of duplication was not the scenario, because the pink sheets were the contract was done before some of these internal issues were done. I mean, balloting of the presidential, who must be on the ballot and all that. It just came. The additional ones just came.
I'm just asking that it means that if they don't get everything, they cannot be actually held liable.
No, but he made it clear that there are wastage in all elections. And secondly, he's also made it clear that the lawyer Addison seeks to establish the point that he caused financial loss to the state, and the judge told him that he should answer. The judge told the witness that don't answer that question.
It's a legal question.
No, it's out of place.
No, it's a legal question.
Okay. That printing more pink sheets.
Causing financial loss.
Causing financial loss to the state because you didn't get to use those ones the second batch you printed.
Either way,
and the judge said
to let go of it.
The judge said you should answer that question.
Look at this. This is what I was rejecting.
I mean that question of financial loss to the state. You see, sometimes let's break things down. Our listeners, on our viewers, to understand something. Henry, let's assume you are a private businessman. All right, you enter you order for 1,000 bags of, let's say, rice to supply TV3 workers in a party, whatever it is, 1,000 bags of rice, and then you are informed that look, on the day of the party, the people who are coming have now reduced. And therefore, with the quantity of rice that you will require, we don't need 1,000 again. All right? Then you are saying that, I've already ordered for 1,000 bags of rice. So you cook all the 1,000 bags of rice. And then you cook all the 1,000 bags of rice. Would that not be wastage? That's the financial loss you are talking about here. You see? You are saying that, look, you ordered for 54,000. So the day of the election, even though it was settled that if the numbers were 8, you still deployed at the order to 54,000. How? This is the problems we are talking about. And the difficulty is that
others who are not invited to the party council.
The discussions. The difficulty is that the difficulty here is that
on this one before you go.
The difficulty here. Yesterday, I had information that I've been allowing you too much to harass me. And so
you see, actually the kids.
In fact, it's the other way around.
You see, that the difficulty here is that the extra one that were even deployed, the duplicate one that were deployed, that forms the basis of most of the complaints before the court.
Okay,
you understand? Most of these pink sheets they were substituted for the original. That's why there are people in court. So let's not belittle the fact that somebody deployed additional pink sheets. It's a very serious matter. If the EC was settled that look, the figures, the numbers were there were numbers for the election were 8. Why deploy the additional ones? So that's and my brother, you have made a point that you are shifting blame to presiding officers. Presiding officers have got a constitutional role to play on the day of elections. So their role at the police station can never be substituted to by anybody. You can't put a party agent for the role of a presiding officer. You can't do it like that. The role of the presiding officer is constitutionally enshrined.
But I think he's also making the point that so it is too for the agents at a point in time. So no matter how much weight to place on the presiding officer, the agent also has a role somewhere.
And nobody can convince me that an agent, a party agent, the role he plays on the day of election can be equated to the role the officer plays in the election. Sure. Can he validate election results? He cannot validate results.
He can only complain.
Yes. Okay. And even the complaint should channel through the same presiding officer. So please, you see, this is a serious election matter, which is before the court. And at the end of the day, we will look at the law, the role each was supposed to play, the quality of start that were taking, the fact that in spite of the start that were taking, there have been problems with the elections. And then the court will look and make a determination out of it. But as it stands now, the EC boss is saying that, look, I accept the responsibility of my agents, which I think is very good, because I've already saying that, look, the ultimate responsibility of all the infractions, the problems, errors, whatever it is, will lie at the behest of Dr. Afarijan.
Okay.
Well, he's the boss of the Electoral Commission.
That's for sure.
And he's the person who has to be given money to go and run elections and to declare the presidential results.
He must account for it.
And he must account for it.
Okay.
And at the end of the day, he has also admitted clearly in his evidence that he never saw a single pin sheet before declaration. At the end of the day, he has also admitted that, look, even if there were errors on it, I did not correct any error on the pin sheet before the declaration.
Yeah. So Gary, I think practically you would agree with him, and we should be looking forward to what happens in future.
Exactly.
Such that
we will have these problems occurring again.
Some very
Yes.
good technical weight is brought to bear on the scrutiny of the pink sheets.
Exactly.
At a certain level.
Exactly.
It's not even possible for him to see all pink sheets across the country, which practically might be the case. I mean,
at
least have some weight.
Henry, all the strongholds of all the political parties
should
they have to see before because you see, if there are errors,
corrections effective,
yes,
in agreement with everybody.
Exactly.
I think we should be looking at next elections as far as
because these are serious. Because if there are errors on the face of the pin sheet, and then you say you have made that admission that indeed there were errors on it, and then these errors have gone into declaration. It's problematic.
That's a very big question, actually, and a good point to make there. But let's look at this academic exercise that he was engaged in. Addison trying to push through and get Dr. Farijan to read in court, a law that's been repealed just so that he can use to refresh his memory and all that. That was overruled.
Anyway, you see,
but just to explain to people, because it took a lot of time to settle on this one.
You see, before the promulgation of the CI 75, the enabling act was the CI 15. That was the law that was being used by the EC itself. You see, in it you have a provision where there are certain penalties of perjury for presiding a party agent. You understand? Now, in the current regulation CI 75, you don't have any penalty like that in it. You understand? So you're only trying to pick that one and then let him read to see that, look, what he has given in evidence as a penalty of perjury on a party agent or a polling agent is really repealed. But with the court, there was a review that, look, this is a repealed law. And you see, when a law is repealed, it's like it doesn't even exist at all. But you see, for law students, you have to read all the repealed laws. If you are learning law, you have to learn.
Can you make references to them?
But you see, you must know. You must know what the law was. You see what the law was, the mischief for changing the law. You see, and then know what the law is now. You cannot start learning law from today and then you only start learning what the law is today. You must start from somewhere. That's why when you go to a faculty of law to go and learn law, they will take you through the law that was before 1992 Constitution. You see, so you must learn everything. So basically, you're trying to let him understand that, look, in the old law, what we had was that there were certain penalties for penalty of perjury. But in this one, I just made an emphatic statement that there's a penalty of perjury, which he was trying to let him that, look, it existed earlier on, but not now. You understand? You see, all this was to show that, look, the party agent, your role as a party agent is not so much as important as the role of the presiding officer, because the presiding officer has got an enormous task on the day of the elections. Because if you are there a day, Henry, the presiding officer he says that, look, these results I have annulled them, these results I have cancelled them. So be it. That is why in places like Nelarugu, in the Philippines place, other place where they realized that, look, there was even overvoting by certain figures. They said that we have annulled them. Because they have the power. Because more or less they are in the shoes of Dr. Farijan in the constituency and in the polling station. You understand that thing? So they have the power to conduct the elections and they play official role in the elections, but not the party agent who is just there as an observer. What if you are there and then at the end of the day, because you are not well resourced, you cannot hire a party agent across the nation? The 26,002 polling stations. It means that you will be shortchanged. It means that the integrity of the elections will be mad because you don't have an agent there. Is that the point that they want to make? You see, the person who is charged with the responsibility to conduct the election, he must ensure that the integrity of the poll is safeguarded. That is the crux of the matter. Because you see, the party agent can be there, all right, but the presiding officer, the official of the EC, he must ensure that the integrity of the polls is safeguarded. Because at the end of the day, the responsibility lies at the doorstep of Dr. Farijan. That is the crux of the matter.
That's the crux of the matter. Quickly, your take on that exercise and what Addison sought to do there. He didn't have his way anyway, but what did it bring to you as a lawyer?
Anyway, I think that, like I keep to say, what I'm seeing from the petitioners, sometimes there's always this act of a lawyer to be mischievous, you understand? And he keeps to say, if you allow it goes in. I mean, Addison is very much informed that, I mean, let me just get it. When it's allowed, it goes in. Every lawyer knows that. So I will discuss this under mischief, a lawyer being mischievous. And sometimes we do that. For instance, I mean, in one vein, you are saying something and you uphold it. Then, at another point, you want to go against it. If our memory serves us right, there was a time when this issue, I think, on the issue of cross-examination of non-adverse witness, when that matter came up, I think that Lawyer Addison was trying to push that the three respondents are all singing from the same hymn book. He also always used those words. He's singing from the same hymn book. So he doesn't see why, I think, at this stage, they want to do, their interests are not adverse. And then he quoted one of the sections. And then when Lawyer Chikata was on his feet and quoted evidence decree, Addison reminded the court that, my lord, counsel is quoting a repealed law because I'm quoting from the Evidence Act.
Oh.
Addison said, I'm quoting from the Evidence Act, where a word subject. Counsel, hold on, let me come there. So this is, I follow a lot. Addison was trying to alert to the court that the difference between, I think it's section 71, cross-examination of non-adverse witness. I think in the Evidence decree, the word subject was there, but in the Evidence Act, I think that word subject has been taken off. It's been deleted per drafting of the new act. So he was trying to remind the court that what Mr. Chikata is reading is different from what he's reading because in the act I'm reading, subject is taken off.
I remember some time ago.
Now, if you're a lawyer who is able to do all this, why then do you come to court 2-3 days later and a law has been repealed? You put it to the witness. It's mischief. I don't get it. Because you're able to tell a colleague when he's quoting an outmoded or more or less an archaic law. You're able to quote even with a deletion of one word. You're able to know the provision and know that one word strikes a difference in this particular drafting of this piece of legislation. Now you come to court and you're the same person who has espoused such a disposition. You now move to the same area you were. And this time around, CI 15 has been basically taken over by CI 75.
So it's not law anymore.
So it's the entire law. Even when it was a word in a provision, 75, Evidence Decree, Evidence Act. The difference is the deletion of the drafted word subject. Even that one we're able to fish it out. Now when an entire CI 15 is no more and CI 75 is in force, is operating, you put CI 75, CI 15 to a witness to identify. It's mischief. It's mischief. So now you got to see that sometimes all these are acts of trying to confuse the witness. An expert witness who's on top of his game, who knows what he's able to do, and then counsel is just there and trying to more or less. So there are so many instances that you get to see that all these things come up. So for instance, when he took the same CI 75, where counsel was trying to allude to the fact that the word perjury is not there. Hey, let's see the provision. Regulation 19.6 talks about party agent swearing to abide by all the laws, the electoral laws. Hey, how is it different if the word perjury has been taken off from the old law? You understand? So it's the same thing.
That is perjury necessarily tells you the consequences you suffer.
Exactly. Of course,
but without it, leaves it open.
If you have a law that says that, I'm saying Regulation 19.6.
That's from a layman's
yes,
point of view.
in law, Regulation 19.6, CI 75 did not use the word perjury, but said that a party agent shall swear to abide by all the laws. Other things, because laws are laws and they are equated to sanctions. So if you breach it, the sanctions are there.
Once you've sworn to it,
the consequences of swearing to that particular disposition. So the use of the word perjury, if it is missing in the new law, doesn't make it look like there is no penalty. There is a sort of penalty. There's a sanction that goes along with this particular part of
the law
provision. Yes, so all Dr. Afarijan is saying to see that he knows that in the law, a party agent who signs or swears to abide by the law goes against that perjury. He will be maybe guilty of perjury or something. He knows per the law. If there's a new law and it's not there, it doesn't. So give him the old law.
Does that make it ambiguous?
It doesn't make it ambiguous. In fact, the new law makes it more clear that
without the perjury.
No, you swear to abide by all the laws.
Okay.
So if you breach the laws, the possible sanctions these are matters of law. So the court or whatever authority, will decide whichever punishment you are supposed to be meted out to you for such a breach of the law. So clear and simple. In any event, we drafters, I did drafting in school. We drafters today want to demystify the law. when you draft a piece of legislation, another man on the street should be able to pick it and understand. In the old law, the word perjury was there. How many guys? Sorry, the use of the word. How many brethren are coming from who understand the meaning of the word the word perjury?
You see the last one.
You understand? How many brethren are coming from who understand the meaning of the word perjury? But if you take the new law, it's very simple. That a party agent shall swear to abide by the electoral laws and rules. It's very simple. Everybody at Kwame Nkrumah who wants to be a party agent, when he reads it, it's very clear and simple. You understand? So these are the modalities. So these are acts of mischief from the petitioners. And I keep to say, I mean, when a cross-examination becomes tough, in fact, more tougher, when an examination in chief has led the witness to lay down the case properly, and no window of opportunity is left for you to do much in cross-examination, all these things are bound to come by. All these things are bound to happen. And anytime these things happen, I want to discuss under mischief. It's one of those weapons a lawyer wants to use out there if a witness will succumb, will crumble to the heat, and then mischievously get a certain evidence through and then get his case. But I mean, that is a clear act of mischief by lawyers.
You have a take on that?
You see, I have always been saying on this platform, my brother sometimes suffers too much to make a point. You see, you were a drafting student, and obviously as a drafting student, you ought to know that the penalty for every sanction must be clearly spelled out in the law. You must know. Now with this one, there's no penalty. There is no penalty. What penalty is there? What penalty is there? What penalty is there? You tell me what penalty has been put in the law. Is a penalty called penalty of perjury? Is it there?
Yeah, so more or less it becomes open.
That's why
it becomes open. So the court will determine at that material moment what punishment should be meted out.
Okay.
So but if you kill it down to perjury,
it's at the discretion of the court.
So does it not come back to the same point that we are making? That the word perjury is not in the law.
It's not.
It is not there.
It's not implied as well.
How can it imply?
A sanction is implied. A sort of sanction is implied.
The word perjury, it is not there. You see, Mr. Draftsman, you are a drafter. If you're a drafter, you ought to know that you have to put everything down on paper. Mr. said the word perjury is not stated there. That is all you are seeking to do.
You are saying it's implied.
Look, that's what I'm telling you. That, it's implied.
You are saying that it's not there.
The court is at liberty. Which punishment? You could give me 2 weeks, 2 weeks jail sentence and not perjury. You could be given anything.
That's what I'm saying.
Yeah,
so it's implied. Doesn't necessarily have
it is not there.
Yes.
It's not there.
There is nothing called perjury over there.
It's at the discretion of the
if you say you can be punished for something, and the punishment should be clearly stated, you understand? The punishment is not there. The punishment is not there. So what are you talking about? Anyway, you say mischief. You see, I don't know why my brother every time. You see, when the thing is so simple, he will still want to, put some spin around the thing. This one mischief. Where's the mischief coming from, Henry? A man sought to explain himself.
You're trying to put a repealed law to a witness in the box.
No.
Is it to refresh his memory?
The man has already given evidence. No. I don't think any way that was going to be tendered. Tendered for what?
But why should you have showed up in court at all?
Just to let the man understand that what he is saying is a punishment for a party.
But the law doesn't exist anymore.
It doesn't exist.
So why bring it to court?
No. But what I'm telling you, Henry, that when you are learning law,
is it to refresh?
When you are learning law, you don't learn only existing legislation.
But you're before court.
You must learn everything.
But you're before court and you are expected to bring laws that are in existence.
But the man already has said, Henry, that a certain state of facts exists. He said it. But what he's saying exists does not exist.
Okay.
What the guy is saying? Yes, it does not exist. It's not in the law. It
existed in the old law 15,
which has been repealed. So you wanted to show to him that look, what you are saying, it doesn't exist any longer. That is all. What's the mischief in this matter? There is no mischief. Everything, my brother said mischief. Everything mischief. Anyway, I think clearly today. If I will take you to one very important gravamen of what even came on the in court, Dr. Afarijan said that he did not hear that the first respondent had made a public declaration that persons who when the machines broke down, that they should be allowed to vote without the machine. But later he did not hear himself, but later it brought to his attention.
I think it was the Sidney Gutierrez interview.
No.
President
Mohammed's declaration that allow people to vote without verification because the machines are broken down. He said he didn't hear himself, but later it was brought to his attention, and the question was asked him, well, what did he do when was brought to his attention, did he make also a public pronouncement to counter that is not the law? Because you see, I've told you earlier on that the rules of engagement, the agreement of all the parties when they went to election was that, look, we are going to vote with verification machine. Unless your hands are amputated, you must be verified by the machine. That was the rules of engagement. That was an understanding between all parties. And I do not understand why my brothers are seeking to shy away from their own agreement. I don't understand. Henry, me and you go into sit down and then we agree nicely on a matter, and then the referee comes and say publicly announce it that these are the rules of engagement. You must go and be verified by the machine. When there's problem, you say no. As for me, if you don't go to the machine, it doesn't matter. As long as your card has gone through, it doesn't matter. You can come and vote. Which runs contrary to our own agreement. Election official in Nadoli Kalio publicly also saying that people were voting without verification machine. He said he didn't hear. You see, so everything that goes on, which obviously he must hear or be notified, he said he did not hear.
He said some of those came to his attention.
And what did he do? What did he do when it came to his attention?
Okay, but he said that he didn't feel the need to do it.
Exactly. That is why I'm saying that, you see, when you see, Afraja sometimes, yes, I know that. All these things,
requesting some of the decisions he made.
Yes,
that's what.
Yes,
that's
because you see, that is why the petition are in court. You see, if all these things that transpired from the way he was so vociferous prior to the elections, I hope you heard the man talk. You heard the man how he was in control of all the proceedings before the elections. All the advice that he was giving, he didn't heed to any advice. He was the alter ego. Everybody, what he says whatever he likes. And now the day of accountability has come. The day of reckoning has now come. It has dawned on him. You are now in the box to answer questions. Look at how he's sweating in the box. It tells you one day that whatever you are doing in this world, the day of accountability will come. Because public office is not held like that. You will account one day.
Talking spiritual terms, or
I am telling you, because now I said I am an ex-seminarian. You see, and you see,
on an account of that,
whatever you do, you see, if it's not on earth, if it's not on this earth,
yes,
when you die, you will account that before your maker. And Afrajan is getting his accountability on earth before you account the one before his maker. You understand? Because obviously, what you must understand, public office, when you are giving public charge, you must know that you are using public money to do whatever you are doing. And therefore, it's not a private enterprise or a private venture. It's a venture for the public. And if you must do it diligently, you must listen to advice. If the man had listened to advice and all the advice from all parties, all the stakeholders, look, we have agreed that no verification, no vote. Who is voting without verification? No, we will not agree. Don't do it. Peter, stop to it. I know. And use one stick to discipline all the parties. I can assure you, the people they will not be in court by this time.
Okay, let's move on to this one.
Yes,
quickly. Let's move on to this one. I believe that will be the last leg, perhaps. The collation sheets, which the petitioners wanted to get Afarajan to bring. I mean, they've had opportunity now to get him to bring a register of those outside, those who are registered outside. He's had the opportunity also to request for him to bring some registers, in respect of certain areas, and I think a couple of other issues. Even with the pink sheets, the leftovers, he's also had it. But this one did not go through, George. That is the collation sheets.
Okay.
They wanted to have that brought in. The excuse of the court was that you cannot use cross-examination to actually begin to call for things that you have not had the opportunity of getting through earlier. That must be good for you, because I saw all three respondents really stand to oppose that or object that. What's the basis?
And he was laughing.
Thank you very much. But before I touch on that, just briefly on, the issue of Dr. Afrajan. Like you said, he's getting a judgment here, but I think it's a good account of it.
I'm saying that he's giving an accountability of his stewardship on earth.
And 2012. But I think that let's be a bit mad, like you said, to handle these issues, because I always ask myself, did Dr. Afrajan go to organize an election in mind of having one person to win? I don't think that was his mindset. I mean, there was an open mind to do the election. The issues that came up is why we are in court.
Would you agree to that?
The issues that came up because
you see, you cannot look at what is in people's mind.
Okay.
There is no art.
So you don't agree to
there
that?
Is no art.
So
And
you don't agree to that?
find the mind's construction in the face.
Okay. And you have heard
understand?
Addison in court that he doesn't trust.
We
don't know what is in his mind.
Yes.
We can't find what is in his mind.
We now know
we
where
can only find what is in his mind, evidencing what is on paper.
On paper, on the face of the picture.
Because even the devil does not know what is in the mind of the human being. He can't know what is in his mind.
Okay. So
don't bring a question about mind here. Because me sitting here, I don't even know what is in your mind. Maybe you want to kill me sitting here.
Oh, come on.
Or maybe because I don't know what is in his mind. So
Judge, good.
The question of mind matter, please don't bring it here. We can only find mind matter by looking at the product of your work. All right, that's what we are looking at.
Okay.
That's what is
I think that it's like I've stated my point that they beg to differ because they don't trust anybody so long as the petition is concerned. But on the coalition sheet, I think the point we are advancing in court is simply this: that first and foremost, these coalition results have not been pleaded, and like counsel always keep to say, you must plead it and speak to your pleadings and stick to it. So first and foremost, these are not.
They have taught you this.
They are not before the court. They have not pleaded it. You understand? There's no claim. There's no claim.
I've asked you. So they have taught you this.
Of course. So their own words, we are playing it back to them. You understand? There's no claim anywhere in their.
That's in your pleadings.
Yes, it's not in their pleadings. There's no claim against the respondent, and specifically the second respondent, of any malfunction or anything with regards to the coalition sheets. There's no agitation about it. It's not an issue. It's not a matter. So they are springing it up, and it's a matter of springing new document or surprises here and there. Element of surprise. If you look at, section 52 of the decree that the court will only exclude relevant evidence. They have the sole power to exclude relevant evidence if it will cause surprise with the other party. I mean, this is clear. This is a clear situation that the court can exclude. And exactly that's what the court is doing. So I think section 52 has come to play. I mean, it's a surprise. Secondly, the argument we are putting across, like lawyer Chachikata said, and lawyer Tony Later also said earlier, they have the document. All parties have the document. Pink sheet, they have it. But when it came to the coalition results, you've got to see that there was a difference that the constituency coalition sheet, parties don't have it. But then the constituency coalition results summary form, they all have it.
What's the difference?
The difference basically is that the other one is the result summary. The summary of the results, how many votes has been cast and in whose favor. 8, for example, let's say the presidential slots, there were 8 candidates. So how many votes has been cast and in which candidate's favor? You understand? That summary of the results is given to the party agents, and they take it, they run with it to their party office. Some of them even make a phone call and correspond the results on that summary form before they take the hard copy, in fact the actual document itself, to the party office or wherever they decided to compile them. So our argument is that they already have these documents. So if you want to speak to it, just let's see how best you're going to address it. But you don't bring the document when it's not in court, when it's not in contention. When we have closed our case, don't forget the respondents. In fact, the respondents have closed their case. As it stands now, only the second respondent will have the chance to re-examine. We have closed our case with our witness. We have cross-examined the second respondent's witness. So when you bring back these coalition forms and you want to speak to it, we'll be given a second time to bite the cherry again. These are the difficulties the court is going to encounter, and the court ruled on it. So more or less, to do away with that one simply is that for expeditious trial, let's move on. We don't need all these back and forth. I mean, they've always kept up a protracting of the trial. When you want to protract the trial, the court cannot basically accept some of these things. So our argument is very simple and straight, that these documents, you have them already. These documents have not been pleaded. I mean, you cannot speak to them, because if the court allow, then what is happening is that, are we going to come back and more or less cross-examine the witness on those documents when we have far gone past that stage?
Okay.
So basically, it's not prudent for the process to allow this coalition thing to come in and take everybody back, because they will have to be given the chance. Lawyer Tony Later and lawyer Chachikata will have to be given the chance to cross-examine Dr. Afarijan on those coalition forms that are to come in, and the court is not ready for some of these. I mean, go back. Most of these things, they say that you can have them in your addresses. There's an opportunity for you to address these things. And he was trying to mention a whole lot of them. And then one judge said that, I mean, basically you cannot take them one of they try to mention all of them, then it simply means that all these constituencies or pinches we are going to talk about, the coalitions you are going to talk about, you have to give the other people to respond to them, and all these will be very cumbersome for the trial. We've gone past the stage. We're only waiting for KPMG to come, and then we take it up from there. So, I mean, there was no need to allow the coalition forms whatsoever to come in.
Okay.
Henry, Henry,
that was a good one for you.
Well, let me just say briefly, my brother made certain factual in inaccuracies in the statement. You see, first of all, the application was not ruled upon; it was withdrawn. See, sometimes I think he's watching the thing, and he takes so much notes, he doesn't really watch what is happening. It was not ruled upon; it was withdrawn. For
okay, the application was various views from the
application
bench.
Was withdrawn but not ruled upon.
Per various views from the bench.
But you have stated here that the application was ruled upon.
Council, whatever it is, the court gave an indication that there's no basis. Council have not laid any basis to introduce those documents. You'll be fishing for evidence, and these are we call it taking a cue from the bench. So they've taken a cue from the bench.
Sometimes I indulge my man too much. I must hit him sometime hard.
So what
I'm saying, the application was not ruled upon. Now,
yeah, sure.
I'm surprised that my brother now is talking about documents not pleaded and documents trying to come in not pleaded in evidence, all manner of things. You see, there is cross-examination, Henry. It is not evidence in chief. There's a marked difference between evidence in chief and cross-examination. Evidence in chief, you lead your witness based on your own story in your own pleadings. Your own story in your own affidavit, your depositions. You understand? So in that, it's highly restricted. That is, when you are leading your own witness, matters that you have not pleaded, you don't lead evidence on them. That is different. This is a cross-examination. The witness is being put in a box and he's answering questions, and certain questions that answer that he gives. There are certain questions that arise out of the answer that he's giving. You understand that we must necessarily answer them. This is cross-examination. So matters that are not clear, that doesn't even arise here at all. You limit yourself to your pleadings based on your pleading when you are giving evidence in chief. These are the differences. So you don't talk about documents not pleaded when it comes to what? Cross-examination. You see, so that one get that point very clear. There's a difference between cross-examination and evidence in chief. That's the point. But you see, even at a certain point in time, we were all here when we saw some of our learned seniors trying to bring in information about biometric, the device machine. Were you there? Did you see? Even though they didn't seek any leave of the court, but that thing almost entered. It almost entered, and if you had entered, but for the vigilance and the resilience of the able hand of the Mr. Addison, if that entered, the court will have taken a look at it, because under Aboba and Adashina, if you sit there and you are docile and you are not vigilant and anything enters into evidence, you are finished.